So what's good? What's good? What's good? Let's discuss. So the judge in the Young Thug case was not trying to hear what the prosecutors was trying to say. So now you know that Young Thug was able to get his 2015 charges, case, whatever, dismissed because the police and the DA was on some bullshit. Check this out.
Order.
I think that his interpretation is right.
Wow.
I mean, I look at the way it's capped, its style and everything else, and it makes sense with what you're asking me to do is kind of just narrowly kind of look at marijuana and not anything else has been seized. He challenged everything that was taken at that particular point in time, and it's clear in the transcript that he did in fact assert the fruit of the poisonous tree. I mean,
So, Your Honor, if I may, when I looked at this case first and I saw his motion, I was sort of thinking the same way as the court. And then I thought, I'm going to check the case law. I'm going to check what the actual order says. And when I looked at the order, that's when I started thinking it might be something different. And whether or not we interpret it a certain way, the language itself, the plain language, and I know that the directive from the appellate courts has been to look at the plain language of statutes, to look at the plain language of orders. The language itself says, the evidence located in defendant Williams' home that is subject to the above referenced accusation number, specifically the just over an ounce of marijuana. If the court had intended to suppress the remainder of the items after just stating, so the court says, the court grants defendant's supplemental motion to suppress any and all evidence located from defendant's home. He could have just said that, and that would have been a different ruling. But instead, the judge then said, based on this ruling, the evidence located in defendant Williams' home that is subject to the above referenced accusation number, specifically the just over an ounce of marijuana, is hereby suppressed. If the court wanted to make a ruling on the fruits of the poisonous tree, it could have, but it's clear from the transcript. And I'm not going to say Mr. Steele didn't argue about that during the hearing.
I'm dropping this only for Nate if he wants to come
ask
up.
The court, hey, Judge Newkirk, can you please make a ruling on the fruit of the poisonous tree? There was no ruling on fruit of the poisonous tree. We're not talking about a second bite of the apple here.
shall be returned to the rightful owner. All personal property in the custody of a law enforcement agency, including personal property used as evidence in a criminal trial, which is unclaimed after a period of 90 days following its seizure or following a final verdict and judgment in the case, property used as evidence, which is no longer needed in a criminal investigation or for evidentiary purposes in accordance with 17-5-55 or 56 shall be subject to disposition by a law enforcement agency. So this one is different than 17-5-30, which is pre-trial. So this is trial evidence, what we do with evidence after the trial of the case. So that, and I mean, I still have an issue of that because you would have still had to return his property to him.
Your Honor, I'm sorry, I have to respectfully disagree with the court. Here, it's not a situation of what Mr. Steele challenged at the previous motion. It's what was ruled upon. There was no ruling upon the.
So if I had $200 and this situation happened, you wouldn't have to return the $200 to me if I won my motion to suppress?
Your Honor, if I had a search warrant that was valid, currently being executed for your $200, and it was for a separate investigation, a separate case, my position is that no, I would not have to return it until that separate investigation, that separate case was done, because I had a valid search. And obviously,
do you have some case law that interprets 17-5-30 in terms specifically the possession of which is not otherwise unlawful? Because that to me says that would be any contraband, weapons, or things that you're not required to, not allowed to otherwise possess. But it doesn't distinguish on investigations or you holding on to evidence that otherwise should be returned.
Your Honor, I don't have a ruling a case at this time. I'm happy to provide that in a supplemental filing. But again, my understanding of the law is and has been that where there is If a search warrant is currently being executed on a cell phone, for instance, the police are allowed to retain that property as part of an ongoing investigation.
But he won the motion to suppress.
On the marijuana case, Your Honor, not.
But you took more than the marijuana. He wouldn't get the marijuana back anyways. He wouldn't get any cocaine that came back anyways. He wouldn't get a gun back if he's a convicted felon. But anything else that was proper, that was taken from that particular, house subject to the warrant, is not otherwise illegal, is returned. The 17530 says shall return and not be subject to further prosecution, because that's the whole thing about it is you don't get another bite at the apple based on this particular evidence. You can go ahead and do something, a separate investigation or whatever, but this evidence is supposed to be returned to the defendant.
Your Honor, our position remains that because there was a separate ongoing investigation for which a valid search warrant was in effect, and there was no ruling as to fruits of the poisonous tree, there was absolutely no reason to return that cell phone. I'm happy to provide the court with an additional brief, but that is our position at this time.
Okay.
Man, so you can see the judge was clearly getting frustrated. But the prosecution just kept coming back with some more bullshit, You can't keep the evidence. You were supposed to return the evidence. The phones, the computers, after they asked. But you intentionally, that's the key, you intentionally held on this evidence for over 5 years, 6, 7 years, 2015. It's 2022. Then you decide to charge with the RICO. A whole bunch of bullshit in the game, in my opinion. But the judge's face just says it all, in my opinion. He was like, this is some bullshit, man. Let's get this part on out of here. And it seemed like the way the prosecutors was going, that was their whole case. If that was their whole case, Young Thug might be coming home soon, a year, 2 years, who knows? Let me know what you think. I'm out of here.